Hello. Hi. Can you guys see me and hear me okay? Oh, hold on. Okay, yeah. I needed to make sure my mic was set up. Hi. Welcome back. Hello, Heller. Hi, 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 hi. Hello, Debbie. I saw Ausane. I saw Laura. Hello, hello. Happy Sunday. Thank you. Yay, yay. We're back. We're back. We're back. We're back. We are talking about Kelsey Fitzsimmons. I hope you guys are having a good weekend. Hey, Marvin. And I saw Evie come in here and Güero. Hello, hello, abuelitas. Thank you for being here and welcome back. We are back to covering, hello, Kimberly. We are back to covering the Kelsey Fitzsimmons case. I just started it. I'm not a professional in it yet. I've been having trouble getting some of the documents, but I did get one that I want to read today. And there's like a 28-minute hearing that I want to cover. So basically, what we learned yesterday from my life is I am newer to the case. I actually heard about it through like other channels. And it is in Mass, which is why it's familiar because Karen Reed case. I was very into the Karen Reed case. But Kelsey Fitzsimmons was going through postpartum depression when she was shot by her colleague because she was trying to unalive herself because she was losing custody of her 4-month-old due to her ex-fiance filing a restraining order against her. And, we talked about yesterday how she didn't have the appropriate treatment and mental health treatment and how she shouldn't be incarcerated. Well, she ends up being released and then she ends up being rearrested because allegedly she didn't meet whatever requirements from the court about her having a scram device. So a scram device is basically an at-home breathalyzer. So I'm a little confused as to why alcohol is playing a role in this. Like, she wasn't arrested, she wasn't drunk at the time. She was going through postpartum depression, which she was diagnosed with, and she was off of work from it. She's a police officer. So I know there's a lot on this case. I believe the documents are hard to retrieve because someone said you have to live in the state, and I think only attorneys or paralegals have access to them, and I am not that. I am Melly. I am just a true crime junkie. And hello, yes. So I am very into the Kelsey Fitzsimmons case. I feel it's very much similar to the Karen Reed case. So I am your host. This is my channel. Welcome, welcome, welcome. We cover true crime here. Housekeeping things. Make sure you hit the like button. Hype this video up, please. Leave a comment. I do have a playlist on this. We are covering a lot of things. We have been covering Mackenzie Shirla text messages. We are doing that after this live. So if you are interested, definitely make sure you turn on your notifications. We are also covering Kata Scott today. So there's a lot going on, but nonetheless, I appreciate you being here. And oh, okay, yes. So second channel. I will be dropping the link to my second channel sometime next week. We are starting a second channel, basically rated R, like adults only. And we're just gonna have fun over there. It's different from true crime. We are gonna be talking about true crime, just not doing live streaming true crime. I just want my true crime stuff to have its own home because that's what I love. So I want to separate the both from whatever else we do with like Melly After Darks. And there's a lot of stuff that I'm gonna be doing. So I will be having a second channel. When I do drop or have that link for you, I would appreciate if you guys sub up over there and do all them things. So I'm going to get started with this case. We are talking about Kelsey Fitzsimmons. Yes, yes. Let me pull up my PowerPoint. The hearing we are listening to today is from a creator, Jess Machado. I don't really follow her, but I know she was involved, I think, with the Turtle Boy case. So she does have this on her channel. So I will link her down below in the description. And you guys are welcome to go over there and do whatever you want. But she did have it on there, and I've seen a lot of creators play this on their channels. So it's nice that she has it up. I do think I found a new contact for this, and he was in my chat yesterday. So I'm definitely gonna reach out to him, and then I'll start dropping his link too if he hooks it up. I'm always willing to pay for things. You guys know that I do pay for a lot of documents. A lot of them you can just pay for them online. A lot of them sometimes are free. So it just depends. But anyways, so the hearing is from her, and then the document I did pay for it online. Just this one specifically. I'm gonna pull up a PowerPoint. So let's touch a little bit on yesterday. The incident occurred on June 30th at about 6:30 p.m. when the officers came to her home in North Andover, Massachusetts. She pleaded not guilty at an arraignment in the Essex Superior Court on August 28th. She was released from custody, I believe, September 9th. I might be wrong on some of these, but at least this is what my research told me. Like I said, I just got into this case. We have only done one live aside from this one. So she was returned to jail, release revoked on September 12th when the judge was found that she was dangerous under the law and held without bail. So she is incarcerated. We do support Kelsey here, Justice for Kelsey. I am working on something so we can do more than her give, send, go. I think my mod Laura dropped it. Let me check the comments. Hey, everyone. Hey, Manji. Hey, Surgeon. It's like the witch trials. I know. Hey, true crime type of mind. The judge in charge is worse than the Judge Canoni. Oh, can it get any worse than Bev Canoni? I didn't think so. Been waiting for Kenzie. Yes, you'll get Kenzie later. I do. Yes, please take care of yourself. Okay, what was I saying? So, oh yeah, I was pulling up the PowerPoint. There's a two-page document. So let's go through that before I actually read. Oh wait, we were gonna do the hearing. Hmm. So let's do this first. Well, actually the hearing happened first. Okay, let's do the hearing and then we'll do the docs. Might be I pulled up the wrong screen. Okay, here we go. Hey, Mal. Good to see you. Okay, this is the hearing from September 11th, 2025. Oh, a little background. You're like, wait, you're not telling us what this hearing is about. So that what I just read to you guys was just like a little timeline. If you want more information on that, you can watch the live from yesterday. But basically on September 11th, I'm reading the script here. During a hearing for Kelsey Fitzsimmons, the Essex Superior Court judge ordered that she be released on personal recognizance under a set of conditions. The conditions included that she was not to see her infant son during the pretrial release period, which I don't understand why this is okay. She was going through postpartum. She wasn't trying to shoot anyone. She was trying to unalive herself. I'm really disgusted with this case. She was required to undergo alcohol monitoring, specifically using a scram device on the ankle, which is an ankle bracelet that detects alcohol in your body. Again, I don't understand. Why are they testing her for alcohol? I feel like this is really messed up. Um, or maybe I'm missing something. Don't know. So don't come for me. But regardless, um, I just don't get it. I don't get why Scram matters. I'm familiar with the Scram device. I have actually had one, unfortunately. So therefore I can speak on the fact that I don't understand why she needed it. But anyways, moving on. So basically, the hearing addressed a motion related to her release condition, specifically monitoring a scram ankle bracelet, and the defense's request to substitute a less strenuous testing given her chest injuries. So again, remember she was pew-pewed in the chest by her colleague. The court rejected the defense's argument that urine or blood testing alternatives should be used instead of a breath test, which the defense said was difficult for her due to her injuries. I don't see, again, why that would be a problem. The judge's decision at the hearing included a revocation of her release based on a perceived violation of the conditions or risk factors, though there is dispute about the legal basis for that action. The defense submitted a medical notice to the court prior to the hearing, pointing out that her rib fracture and retained bullet fragments, and argued that the court incorrectly stated it lacked a medical evidence. So we're going to listen to the 28-minute hearing. And then we're going to read a document.
Good afternoon. Calling home up first is KELSEY FITZSIMMONS. This is docket number 2025-311 before the court in the defendant's motion. If the parties will please identify themselves for the record.
Good afternoon, James Gubachowski on behalf of the Commonwealth.
Good afternoon. Good afternoon, Marion Moriarty for the Commonwealth. Good afternoon. Good afternoon, Your Honor. Martha Coakley for the defendant, KELSEY FITZSIMMONS.
I have the closed captions on, but let me know if you would prefer them off or on. I don't care, whatever you guys want.
Hello, Your Honor. Tim T. Brado for KELSEY FITZSIMMONS. She's present in the courtroom today for the record to my left.
Good afternoon, Mr. Good afternoon, everybody in the courtroom.
Thank you.
So I received the defendant's emergency motion for immediate release from the Graham order. So I'll hear from the moving party.
Thank you so much, Your Honor. Judge, this is an issue that causes Ms. Fitzsimmons a lot of pain. And I don't want to conflate her being able to pass the test because she's been passing them, but she has about 4 hours of pain and dizziness afterwards. And you know, I don't think anyone, and I know the court would share my thought that this shouldn't be a torture device for her. This shouldn't be something that causes her pain, impairs her rib healing, et cetera, et cetera. So, you know, we're not trying to get any sort of advantage over anything. We just want her to not, A, to not be in pain for hours after these tests, and B, you know, we just want her to not have the anxiety that if she has a difficulty doing it, that she's going to get a knock on the door and get locked up. We were told by the Elmo people that, you know, they may have to issue a warrant, and thankfully they didn't. And we appreciate, you have Mr. January's email regarding his own observations about what happened. And, you know, I think that says it all. That's someone that has no bias or interest, and, you know, probation enforces court orders, and that's that. And he is telling the court this is a problem. And, you know, this is something that should be addressed. And
okay.
So I see this as a simple adjustment of terms.
I don't see it that way, just so you understand where I'm coming from. I don't see it that way.
Okay, can I?
Okay.
I don't understand what you're saying, Judge.
Okay, what I'm telling you, it's not a simple adjustment. One of the reasons she was released, and one of the reasons to ensure the safety of the community was for her to be alcohol-free. If she cannot do that or will not do that, that changes everything.
She's happy to be alcohol-free. She doesn't wish to be alcohol-free. It's just the means of determining that's the adjustment. That's what I mean.
I don't understand why this judge has such an attitude. Who even said she wanted to be drunk? I missed something. She should have got supervised visits. Again, I don't know why she didn't try to hurt the child. Not if it's he said, she said. In my eyes, I don't think she tried to hurt the child, and I don't understand why they're assuming she's drunk. I haven't read that she has an alcohol problem or anything, which I don't think she does. So I didn't read anything on her being drunk that night when she allegedly flipped out either. So
when I say this is an adjustment that.
Well, a scram is what was ordered. Now, was she unable, when you said that there was a knock on the door? Explain that to me. What happened?
No, Judge, that we don't want to have a knock on the door. She's living in fear of there being a knock on the door because of these tests. And it's just not between the physical and then the mental anxiety. This is a very significant issue for her.
Okay.
And that, you know, we just want to adjust whatever means the court wishes to test her or figure this out is fine with us. But this is just a very difficult environment. And just, that's something that I just want to ask the court to adjust somehow.
Okay, so you're asking the court to adjust the court's order that's been in effect for 3 days with no medical evidence to support your claim that she cannot do it.
Well,
yeah, I agree. Lindsay says the entire case is he said, she said, and my partner said no body cams, by the way. Yeah, we covered that yesterday, and at that point, no body cams. I'm shook. I thought everybody was supposed to have them. Well, by everybody, I mean every law enforcement. I don't know why that's not a thing in Massachusetts, or maybe just this county. I'm very confused about that. This judge has a problem. I don't know if she's coming in there knowing something, thinking something, assuming something, but she needs to just take it down a notch, because we don't understand why you hate KELSEY so much, and we don't understand why you think she's a drunk. But yeah, I think this judge is on one right now.
I think you have 2 affidavits and the email from probation. I think that's pretty persuasive evidence that this is extremely difficult.
The email
for her.
from probation is not evidence. If you have any evidence, now is your opportunity to submit it.
I don't understand the court's position. That's not evidence.
Okay, it's an email, it's hearsay. Commonwealth, do you have a position as to the submissions of an email as evidence in this hearing to relieve the defendant, Ms. Fitzsimmons, of a condition that's been in effect for 3 days?
I don't want to put anybody on the spot, but we have the person who sent that email here.
Okay. So you have a burden, it's your motion, what do you want to do?
Well, Judge, I don't think that is the court saying that papers and emails and affidavits are not sufficient?
This is an email from a probation officer. The court gives that 0 weight.
Well, then you have an affidavit from Ms. Fitzsimmons and you have an affidavit from her mother of the physical observations of what happens. I think that
I don't understand what the problem is with just not getting her mental health. I don't understand why she's incarcerated. I really don't. It seems all one-sided and not Kelsey's side. Yeah, recap is she was going through postpartum depression, Mal, and she was shot by her colleague when they were serving her restraining order when they took her baby, her 4-month-old baby. And they're saying that she was trying to shoot her colleague who she was friends with. And so they let her out of jail and then they rearrested her because she allegedly wasn't complying with the scram device, which is total bullshit because you could do urine test, you can do blood test. I mean, there's many things you can do to be alcohol tested. And I don't know why they're alcohol testing, so don't come for me on that part. I didn't see anywhere that she had a drinking problem. So I find it odd that they're relating a domestic violence case with the postpartum case with a custody case to this alcohol thing. Usually a scram device I thought was prescribed to people dealing with crimes that they committed while drunked or whatever, while drunk or DUIs generally. So I'm a little confused on that part and I'm not a lawyer, so don't come for me. I'm just a person on YouTube that likes true crime. So that's what I don't understand, why they couldn't just offer her to do something else rather than the scram, because she got shot in the chest. So when you have scram device, it's like every 2 hours, morning and night, you get tested. You have to blow into this device at home and it's a pain in the ass. And so she couldn't be doing that because she was shot in the chest. And so they sent her back to jail. And so she's incarcerated dealing with postpartum depression. And her ex-fiance, who she was supposed to marry last month, is trying to take everything from her, including their newborn child.
that's, more persuasive evidence than a doctor saying something to the effect of, I think it's self-evident and it's common knowledge that if you have broken ribs, that it's hard to breathe.
What
And-
evidence do I have that she has current broken ribs and that she's suffering from broken ribs at this time?
Well, you have an affidavit from her mother, you have an affidavit from Ms. Fitzsimmons, and the other day we were here, I submitted I believe I submitted the instructions from Mass General about broken ribs.
Okay.
I mean, I just would just argue that it's somewhat self-evident as well. Thank you. That it's somewhat self-evident as well, and that, she's having great difficulty here. It's been observed by probation, it's been attested to by her mother, and it's been attested to by Ms. Fitzsimmons. So it's just a very difficult scenario for her that luckily she has passed the test, but then she's got hours of pain afterwards. And the one that she had difficulty with, out of an abundance of caution, we were dealing with Elmo and we were informed that they may issue a warrant. And
So I want to
then-
hear about the one she had difficulty with. When was that?
Oh, Lord. Dude, what?
Well, so that's what I was saying, Judge. I don't want to conflate passing with not having difficulty. She has difficulty with every single test. And so she passes them in great pain. So she's had difficulty in every single one, it's in the affidavit. So she has difficulty on every single one. So that's different issue than passing the test. So she's experiencing difficulty all the way through. But the one that she was unable to was 9/9/25 at 3:09 p.m., I guess.
And was that a required test? that she was to do?
Yes,
And she was unable to perform it?
correct.
Okay, was she unable to?
So if you
perform-
guys are not familiar with the scram device, like I said, it has you blow. So like it's like every 2 hours or whatever the hell it is. It's a lot throughout the day. You have to like bring it to work with you. You have to do whatever you have to have it on you basically at all times. You have to charge it. It gets locked. The police come. Like it's a whole pain in the ass. So she didn't blow at a specific time that it wanted her to blow. And so they thought she was like breaking the law. And it's actually really not this way. I don't know why, if there's a probation officer involved, the department, I don't know why they're being so harsh towards her, because like here locally, if that happens, they generally call you and they're like, yo, where are you? What are you doing? Like, why aren't you blowing into this device? Some people do call you like that I guess it just depends who you get at the scram place, or the police department, basically. So I'm a little confused why they're so harsh with Kelsey, knowing and taking in consideration what she's been through.
No.
What happened?
No. So this, since she's been released,
Yes, swear in office.
Would
The
you raise your right hand,
probation
please?
officer.
Do you solemnly swear you will make true answers to such questions that may be put to you by the court or upon its direction, so help you
I
God?
do. Or if I could just pass this up, this is
Sure.
information pertaining to all of our grants.
And is that being submitted, Attorney Braille, as an exhibit for the purposes of this hearing?
Judge, I'd be more than happy to do that.
It's not more than happy to. You're either doing it or not.
Yeah, sure. Go right ahead, Your Honor.
Okay,
It
so
just says that she passed the test, so which is not an issue. The issue is that she's in extreme pain while doing it. Whether she passes. or not.
Okay, so there's one, Officer January, that says incomplete at 9/10/25 at 3:09 PM. Is that right?
Yes, that's correct.
So what does that mean?
Yes. So what it means is there's a scheduled test that's programmed daily for her to be alerted and to initiate a test. And that happens. And so initially she answers the alert and attempts to take the test, but is unable to complete the test. And based on my information, my conversations with Elmo is that is when she has difficulty either blowing as hard or as long, or a combination of both, into the machine to complete the test. So what happens after that is there are additional attempts to complete the test, which she tries, and then ultimately on that particular date, she successfully completes and passes the test on September 10th at 3:50 p.m.
Okay, what I have in front of me is an incomplete test at 9/10/25 at 3:09 PM.
That's correct. And then if you just look
And then
right
it
above
says
that,
passed at 9/10/25 at 9:30 AM.
okay, so you're looking,
So basically, it went off for her, I think, when she was supposed to go to bed, because it generally it goes off between 9 and 10 p.m. or I think 9 and 11 p.m. At least from my experience, it was like between 9 and 10. And so she probably didn't do her nighttime, late night blow. And so it went through the morning. And so that's the next reading that the attorney, I'm assuming, is saying right there, like, well, she corrected it. But generally, the police department is supposed to call you and be like, why didn't you blow, at least from what I'm familiar with and I have heard things of. So I don't know. A little shady.
the second document, it's multiple pages.
Mhm.
I think if you just go up instead of the one above it, the
Okay.
incomplete is the.
So it's 3:09, it's incomplete, and then at 3:50 she passed.
That's correct.
So that's a period of 40 minutes?
That's correct. And you'll see the same thing.
So the other one, which is
September 9th, yes.
September 9th,
again, at 3:00.
But she,
The test is initially incomplete.
at 3:09, and then it's complete at 4:21.
Yeah, 4:20, 4:21.
So there were 2 times that she had an incomplete test. Is that
Yes,
correct?
incomplete, and
And what's the procedure of the probation department when somebody who has a condition of release to have scram and to pass the scram test in a very serious case if they're incomplete? And I have 2 incomplete tests and I was not made aware of either one of them.
so my,
Again, why is she doing scram? Is she a violent drunk? Like, I am so confused why she's even in jail for this. I really am dumbfounded.
my first job when we get an incomplete test is to gather more information. And so, which is what we do. And so in response to the incomplete test, we call Elmo, we gather the information, which is she answered the alert to take the test as scheduled. Unfortunately, she was unable to complete the test because she was unable to blow as long or as hard as needed to complete the test. So ultimately, at 4:20, she completes the scheduled test. There may be additional attempts in between, but ultimately she completes the test.
So that's for a period of
And so
an hour and 20 minutes.
that's correct. Now,
What? An
in
hour?
conjunction to the hour and 20 minutes, we also know that
You guys, this is ridiculous. Like, I've had people, people have gone sometimes up to 2 hours without it going off or them calling you or trying to find you. So with the person taking the test and it wasn't complete, yes. So it goes off, it goes beep, beep, beep at like 9:30 or whatever, late night blow. It tells you how to blow. Like it times you as you're blowing because you're supposed to like blow out for like 10 seconds and then suck in or vice versa. And so when you don't do it, I guess, hard enough or blow hard enough into the device, it basically docks you as incomplete. So 1, it's a way they make a bunch of extra money because when you get docked, you also have to pay for that. And then 2, you either have the police calling you or coming after you, or in court, you get reprimanded for it because it's like, it shows you up as incomplete. But she wasn't doing it as an incomplete because, oh, she was out getting drunk or drinking alcohol. She had an incomplete because she had got shot in the chest. So all throughout the day, she's blowing. She had broken ribs. She was shot in the chest. And then at night, she was having a hard time doing it. So that they're considering those as incomplete. And that's why they brought her back into jail. It's literally quite bullshit. Like, I am very familiar with these devices. And if you are familiar with them, like, wow, that's like really messed up. That especially with someone going through postpartum. And she's not even a violent. I mean, I don't believe she was trying to shoot her colleague. I don't believe that from the bottom of my heart. I don't. I think she was really trying to unalive herself. And so I guess that would lead me, for my opinion only, that she wasn't trying to just bullshit the machine, the scram device. For her to be incarcerated for that, I think is really not right. I don't think it's right.
and I observed it firsthand, that whatever the injuries are, which I don't know, and actually doesn't really matter to me. But when I was doing the installation process and observed what was genuine pain, like genuine
Okay.
pain. So I know,
Any objection to any of the terms used by the
No.
probation officer? Okay.
so we have all that information. We don't deem that non-compliant. She's attempting to take the test and she ultimately passes the test at 4:20. So with all of the information, that's not non-compliant. That's compliance, and with her obstacles.
What do you,
and
I'm getting confused. What do you mean compliant?
That's
As far as when
that's-
she was initially,
That's compliant with scram testing. She was ordered,
when she initially was, started to be monitored by Scram and you put and you went through the preparations. Is that
Yeah,
right?
that's correct.
Okay. So when something is incomplete, do you typically bring it to the attention of the
No.
court?
No, that's not what we do. So if something is incomplete, as in this case, at 3, on September 9th, at 3:09, we have an incomplete test, which is a scheduled test.
Mhm.
And then we have, that's simply not the non-compliance. If she had missed the test, that would generate additional responses from Elmo, and then that would determine whether or not there's actual non-compliance.
Yeah, exactly. He said it would have involved usually it alerts when you miss. It is corruption. Remember everything we read on the chief policeman yesterday. He's shady as hell. True Crime Type of Mind says the probation officer works for the Commonwealth. He's the one trying to tell the judge that she was having trouble and the judge just don't care. Okay, so it's a probation officer speaking out for her. Good to know. Thank you. She's an officer and now I know. What is wrong with this horrible judge? I don't know. I don't know. Literally just as bad as Auntie Bev Canoni. Thank you, Lily, for becoming a new member. Thank you. Appreciate you. It's a great way to support the channel. Witch hunts, I know, en masse. I agree, Sarah. It's wild. Why is she going to jail? She is in jail. Yeah, she is the one that got shot. She's in jail because she failed to blow into the device.
If someone missed a test because they were down in the basement doing laundry and then came up and realized that they had a test, took an on-demand test 20 minutes later and passed the test, which means there's no alcohol in the system, we don't deem that as non-compliant. That's compliance. If they missed the test and additional notifications were made by the electronic monitoring office regarding the missed test, and she failed to respond or she failed to take an alert for another on-demand test, now that's non-compliance, and we would initiate a pretrial violation notice.
Exactly. He's saying like, because usually it gives you a chance. So if you miss, it like stops beeping for a minute and then it like 3 minutes or 5 minutes later, it beeps again. And after that time, generally they call you, the company or the police department, whoever's monitoring it, and will be like, why aren't you blowing into your device? You have like 20 minutes to do it or whatever, or charge your device or whatever it's going on.
Notify the district attorney's office. This particular case, I don't deem non-compliance because she's complying with the scheduled program. I'm aware of pain based on my observations from the installation process. So as long as she's attempting to take the test, continues to attempt to take the test, and then ultimately takes the test, that's not non-compliance. That's someone that's,
Well, that's
for
your
me.
That's your position. That's non-compliant.
Well-
It's really up to the court to decide whether somebody's compliant or not with conditions of release.
Wow.
What you're saying is
Wow. What a rude ass.
those
Oh, this lady.
situations you
ever-
described is what you deem as appropriate to bring before the court.
It would, so I guess it would never be brought to court by way of a pretrial violation for an incomplete test with the information that I've talked about. So no, an incomplete test does not initiate a pretrial violation or from our end.
Right.
Because there are many reasons for a test to be incomplete. And there are circumstances where someone misses a test and then takes an on-demand test. That's not intentional non-compliance. And the goal is to test to ensure that the person's sober, and that's not, we don't deem that non-compliance. We never have, and we never would, in this case, initiate a pretrial violation proceeding based on an incomplete test. that was subsequently passed. And so,
You guys want to know what's funny and ironic too? And I'm not condoning you do this if you have a scram device, but like generally once it goes off at night, it's a very few times, depending on the length amount for the length of time that you have to have the device, like the court orders you. Generally at some point it just cuts off for the night. So like technically you still can drink when you have a scram device. I don't recommend it, but people break the law and people don't care because it's like for a long period of time it does go off during the night. So it's almost like, sir, ma'am, what is even the point, right? But I guess the point is for you not to be drunk off your ass all day long. So it goes off all day long. She wasn't drunk though.
the schedule for her to be tested is something that we discussed. Wasn't ordered by the court. The court ordered someone to be alcohol
What do
free
you mean we discussed? So she knows
I
when she's going to be
discussed-
tested?
with Ms. Fitzsimmons. I discussed with the defense counsel about creating a testing schedule because it's more practical to have a schedule in place. There was no schedule that was ordered by the court. There's no
I've scrambled.
frequency of testing that was ordered by the court.
It was
4 times a day, 3 times a day. None of that was ordered. She was ordered.
It was random screens, excuse me, Ms. Officer January. It was random screens. Now you're telling me she's on a schedule to get tested? Is that what you're telling me?
We created a schedule,
With
as we always
the-
do,
Okay.
as we always do. Not in this particular case. We always do.
It was random screens that were ordered.
Judge, I don't have that. I don't have random screens anywhere in my materials for the record.
Okay,
I don't know nothing about random screens.
okay.
Judge, just so I could clarify that. When we get an order, someone's placed on pretrial conditions that include remain alcohol-free with scram testing. We always default to creating this testing schedule
Okay.
and up to 4 times a day. So we'll schedule one for the morning, we'll schedule one for the mid-afternoon, we'll schedule one for the evening, and if we have to, we'll schedule one for later at night. And that's to ensure that sobriety throughout the day. In this particular case, we created a schedule for her to be tested at 9:30, 3 o'clock, and then at 8 o'clock. The only way we would not enter a schedule is if the court specifically said, I want the test to be done randomly. I don't want her to know when the test is coming. And the test to be done randomly. And at that point in time, we would take her off a schedule. And then we would notify Elmo to be tested 4 times a day at random.
Okay,
So that's done on this case and it's done on every case.
okay. Attorney Bridle, do you have anything else to submit?
Judge, I would just offer, I respect and I heard your Honor's take on the probation email, but for the record, I would move that into evidence as well. And I just want to also.
Commonwealth, do you have a position as to the admission of the email?
Well, I think we just heard with the email.
All right, so the email is excluded. Anything else, Attorney
No,
Bridle?
my objection.
Wow.
Sure.
And Judge, I just want to state that on the pretrial conditions of release, it says comply with remote alcohol breath testing.
Okay.
Um,
I don't know if that's what was ordered. I'm going to go back and listen to FTR.
I can tell the court from where I sit, I didn't remember any use.
I mean, you may very well be right, but I'm going to go listen.
Judge, I just want to clarify something. My email, and I know but it's important that the court knows, I didn't make a recommendation that a scram condition be vacated. I never did that. I never suggested, it's all that email was.
Attorney, Officer January, nobody's asking you questions. Your testimony is complete. Are you asking to make a statement to the court sua
Well,
sponte?
What is wrong with this judge? Dude, she needs to get that stick out of her ass, please. I would greatly appreciate that. Sorry for my French. I don't know what her problem is, but she needs to chill. She needs to just smoke one, relax. It's gonna be all right.
If the court's under the belief that I recommended that that condition be vacated or removed, then yeah.
I
Because
haven't
this-
said anything one way or the other, sir. We're here for one purpose and one purpose
Okay.
only, and that's
Thank you.
for the motion to vacate the scram device. So do you have anything else to submit, Attorney Brado?
No, Your Honor.
Okay, Commonwealth, do you have anything?
No, I have no evidence to submit other than the arguments that I talked about, how important that the Commonwealth's belief is in light of the court releasing the defendant, that testing be done.
Okay. Attorney Brado, first of all, I do have a question. So Ms. Fitzsimmons is able to do the scram, is that correct? Or is she not able to do it? I don't know. Is she not able to do it?
I think, that depends on whether the court is willing to tolerate that, the material represented in the
The court
affidavit.
is not tolerating anything, okay? Let's be clear. I'm not tolerating anything. The court is not tolerating anything. Ms. Fitzsimmons is a defendant. In lieu of incarceration, my order was that she submit to scram. If she cannot do that, I need to know that. Can she do that or not?
She can do it
Okay,
under the terms that are
So-
laid out in the
so
affidavit
you're saying she can do it on her own terms?
with significant pain.
She has she was shot in the chest, ma'am. Literally had broken ribs. Even if you had like strep throat, it would probably hurt to blow into this thing as much as they have you do it throughout the day. Like, I'm really not playing with you guys. It's crazy. It's like, I think it's every like 2 hours, like 2 hours and 15 minutes. At least the ones I'm familiar with. I don't know if they can pick the times, or I'm really not a professional when it comes to like that part of it, but you're breathing in it all day long.
And dizziness and having to recover for several hours.
I understand what you're saying. It is certainly not the court's intention. It's not the court's position to have Ms. Fitzsimmons in any pain at all. So I appreciate your argument. Do you have anything else to add?
I would suggest, Judge, that I think there's other ways to do this. If the court wishes to have her tested for alcohol compliant, lack of alcohol, that's completely fine with the defense. But just the means that's being employed is kind of a torture device for her.
Okay.
And so we object on due process grounds to that.
Oh, okay.
But
It is not this court's intention
I understand.
to torture Ms. Fitzsimmons at all. The court's goal is to make sure the community is safe and Officer Noonan is safe. So I hear you loud and clear that the defense views Ms. Fitzsimmons having to do the scram as cruel and unusual and torture. Is that your position?
Yes, cruel and unusual and torture. Yes, Judge. Take that. Yeah. Just shut up and take it. Do a dang blood test. Urine, I feel like, is just as accurate as the scram. Like, and really, they don't even report it to the court. I think it's at the discretion of the police department or the police chief. From my experience, it was the police department. It was like after so many times, whether it was like 3 or 4 times, they would like dock you for it. And then after so many write-ups, they would like report you to the court as like failed. So she wasn't even anywhere close to that.
That's an Eighth Amendment position. I suppose that
Okay.
can be put in there as well. But Judge, I think that, that there's probably other alternatives that she could do that I believe are out there but I know that might step on the court's other order for house arrest, that you would have to go to a facility. I know there's like urine tests and other things like that. So I know there's other possibilities out there that.
But they could do house arrest in the scram at the same time too, guys. Like, I believe you can have the bracelet that does both. So if she was on house arrest, I don't see why it was a big deal for her to do scram at home, which is why she was doing it at home. But I don't understand why they wouldn't just let her do like urine test.
Again, she's not trying to use this to create a situation where she can go drink alcohol.
Okay.
Not at all what this is about. So I just want to ask the court to consider any other alternatives that might not pose this type of an issue.
Okay.
Thank you.
Attorney Gubitosi or Attorney Moriarty, do you have anything to add?
No.
Okay, I'm going to leave the bench for a few minutes and I'll be right back.
Court, all rise.
I think that's the end of the hearing.
Occasion.
Oh, no, it's not.
Okay, good afternoon, everybody. So I have reviewed everything again that's been submitted to me. And I will state for the record that Fitzsimmons has moved twice in a 3-day period to amend her conditions of release. On neither occasion has she submitted any medical evidence to support her claims. The imposition of conditions is the court's order after careful consideration of the evidence to fashion the least restrictive conditions that will reasonably assure the appearance of the defendant and the safety of all other persons in the community pursuant to General Laws, Chapter 276, Section 58A2B. Just days ago, the court concluded that the condition of remaining alcohol-free and submitting to SCRAM monitoring was necessary to ensure the safety of the community. After a thorough review of all of the arguments and submissions by the Commonwealth and Fitzsimmons, that conclusion remains unchanged, regardless of Fitzsimmons' claimed physical limitations. Based on an affidavit submitted by Fitzsimmons' mother, the testimony of Assistant Chief Probation Officer Jeff January about his observations of Fitzsimmons' apparent pain during the SCRAM installation, and the representations of Fitzsimmons' counsel that it would be cruel and unusual punishment and torture to continue to require Fitzsimmons to comply with the condition of being monitored by SCRAM, the court concludes that Fitzsimmons cannot abide by the condition of being monitored by SCRAM. Without this condition, which ensures that she does not consume any alcohol, the court cannot assure the safety of Officer Noonan and all other persons in the community. Accordingly, the court's prior order of release is vacated, and Fitzsimmons is ordered to be held without bail pursuant to Mass General Laws, Chapter 276, Section 58A. And a
Your Honor,
written
may I
order will follow.
address?
And there's a discrepancy here, guys, between 58A and 58B. I'm not a lawyer, but I know that there's like something wrong with that. And then she tried to file charges for 58A. I don't know what the hell that means. I was just reading about it. So again, don't come for me. I'm just a little human reporting on the true crime.
That's the court's order. Thank you.
All
Your
right.
Honor, I object. I ask you to stay your order pending the SJC.
Is that Kelsey in the background crying?
And there are other alternatives Your Honor can accomplish.
Wow. Wow. That's so messed up. I'm disgusted. I'm horrified. What if that happened to you or someone you knew? You know, not that I would wish that upon anyone. I'm just saying. Let's pull up. That is brutal. We're gonna read a 2-page document and then until we get into the big one. That's messed up. It's messed up. So this document here is a motion to reconsider imposition of custody for reinstatement of original terms of release with order for alternative alcohol testing. So that hearing was on the 11th, and I think this was filed, I don't think I know. Oh, this is like the same day. It says, now comes KELSEY FITZSIMMONS, defendant herein, and respectfully moves that this court reconsider this revocation of her release and instead impose alternative alcohol testing by random urine tests set forth in the attached email provided by probation. As grounds therefore, the defendant respectfully states that returning her to prison is not the least restrictive alternative to effectuate the court's aims and concerns regarding alcohol testing. Instead, the court can order an alternative to the SCRAM testing whereby the defendant submits random urine tests to the AverHealth contractor as set forth in the attached email from the probation department. Undersigned counsel has been informed by probation there is a testing facility approximately 10 minutes from the defendant's house on Essex Street in Lawrence, where she can be driven as per the court's order to be tested in random fashion. And she's 10 minutes away. I'm disgusted. The random testing involves a probationer calling every morning to see if she's required to go to the facility for random testing. Her mother or father are available to transport her to that facility wherever the testing requirement is invoked. The court can accomplish its goals with this alternative rather than incarceration and without causing Ms. Fitzsimmons undue pain. Undersigned counsel has been informed by probation that this testing method is available in this case. Thus, the court may order a less restrictive alternative than the incarceration that simply addresses the court's concern over alcohol use and the safety of the community and any person without the severe alternative of incarceration. The defendant presented to the court that attempting and completing the scram caused pain at the time as well to 3 to 4 hours thereafter. The court acknowledged she did not want the defendant to be tortured, but did consider the other alternative that would accomplish the goal without pain to the defendant. The court's revocation of all conditions to send the defendant back to jail is worse by far than requiring her to submit the scram. Aside from her total loss of liberty, the defendant is a police officer and former corrections officer who would face serious risk of bodily harm in such a facility. Ms. Fitzsimmons is requesting an expeditious determination of this issue and does not request an in-person hearing. Defendant requests an expedited response from the Commonwealth reporting their position to the court, consistent with the case law providing that relief in this type of case must be speedy if it is to be effective. Conclusion. For the foregoing reasons, Ms. Fitzsimmons respectfully asks the court to reconsider its order of incarceration on this date and return her to house arrest with the same conditions as ordered, expecting a random urine requirement as requested above in lieu of the scram device. Wherefore, defendant respectfully requests that the court issue appropriate orders in the interest of justice as set forth, dated September 11th. And then the next document, it's a 2-page document. This is messed up. This is so messed up. Wait, which one do I want to read first? Okay, I'll read this one first. Who is the judge, Melly? Oh, it's it should say on one of these docs, right? Yes. I'll let you know when I come across it again. Yeah, because at the top it just says Superior Court, and then it has all the lawyers. We'll come to it. We'll come to it. Oh, here, you know what? I actually think I'm gonna actually look it up because that's a good question. Who is the judge? It is Judge Kathleen McCarthy Neiman. That's her. Let me see if I can find a picture of her, of the judge. No. At least not right off the bat. But yeah, that's her name. Judge Kathleen McCarthy Neiman. Bev Canoni, number 2. Is that Judge Bev's sister? Yes, it is. Okay, this next document is a motion to reconsider imposition of custody. Wait, did I just read that one? No, I'm confused. Yeah, I did. This one is, dependent supplemental exhibit filing on her pending reconsideration motion. Now comes the defendant, KELSEY FITZSIMMONS, and respectfully files the attached doctor's letter from Jonathan Parks, MD, the trauma surgeon that attended to Ms. Fitzsimmons during her stay at Mass General Hospital. In the hearing that preceded the pending reconsideration motion, the court expressed its concerns that it desired medical evidence relative to Ms. Fitzsimmons' condition on the assertion that her broken ribs could impede the deep breathing necessary for the scram device, causing pain and trauma to the defendant. The defense has obtained a letter from her surgeon addressing these concerns and corroborating Ms. Fitzsimmons and her mother's previously filed affidavits and files a true and accurate copy herewith. There is no request for impoundment. Wherefore, the defendant requests that an alternative means of alcohol testing be implemented, such as a urine testing at Andover Health Systems, a Commonwealth vendor 10 minutes from the defendant's family residence and that the defendant be returned to her previously allowed terms of release. This is September 15th, so 4 days after the hearing. And doesn't the Commonwealth know that anything involving them is going to be questionable after what they did to Karen Reed? Like, I don't get it. I just don't get it. I'm being sarcastic too, by the way. This next document is a letter from the doctor, the MD. So let's read through it really quickly, just so we know. Hey, Mary Beth, good to see you, love. The requesting another judge is a good way to get someone worse, but this judge didn't seem to do anything wrong. The lawyer said she can do the test. This isn't adding up. Basically, I don't care who the judge is. They need to just let her do the urine test. That's it. That's where I'm at with this. I don't understand why it's allowed. She didn't get a DUI. Like, she wasn't drunk handling a firearm. Like, I'm really concerned of the whole drinking thing. Generally, they don't give scram. I mean, I guess it depends really on the crimes. But like, generally you get scram if you're drunk, like a drunk kebab, which happens. You can get them on a DUI, on a wet and reckless. Like, they're very easy to get. We are no judgment zone here. We don't judge people here based on their past. I just want to say that that's a thing on my channel. Like, we don't do that here. Whatever things happen, we are all here to be better human beings. And like, I have a problem with this case. Moving on. I don't want to get too distracted. September 15th, KELSEY FITZSIMMONS to the Honorable Court. This is from the Massachusetts General Hospital Trauma Center. I was a trauma surgeon on call when Ms. Fitzsimmons was admitted to the Mass General Hospital with multiple gunshot-related injuries. Her documented injuries included 1, gunshot wound to the right hemothorax with retained bullet fragments in the right upper back. Moderate right hemothorax requiring chest tube placement. These are her injuries. Exactly, Sarah. Everyone makes mistakes. We just need to learn from them. Right, middle, and lower lobe pulmonary contusions with active bleeding. Grade IV hepatic trauma with active bleeding from the right hepatic lobe. Comminuted right posterior 12th rib fracture, right anterior 11th rib fracture at the costochondral junction. Her treatment course included multiple procedures, including chest tube placement, percutaneous drainage of the hepatic collection, and ERCP with biliary stent placement. In my medical opinion, a fracture of the 12th rib can cause pain that may persist for several months after the injury. The severity and duration of pain following such a fracture may vary, and it is difficult to predict how long symptoms will continue given any patient. So basically, like, it differs per your body, etc. I mean, scientifically, I don't understand. This isn't very hard to prove. Additionally, retained bullet fragments can also cause chronic pain that can be exacerbated by movement such as deep breathing. Okay, this next document is that's related to her case. This next document we're reading, we're kind of jumping around. This one is from the probate and family court. This is the order that her ex-fiance is requesting, like, full custody of their child. Which one, I'm also confused. Like, I guess I should talk to like a mass lawyer or something. I'm confused again why the baby was taken from her when there was no CPS involved or any professionals educated to deal with someone experiencing a mental health crisis episode and someone involving a child. I don't know. Police, with all due respect, are not trained in these professions. Like, they're trained in being police officers. A police officer could have no effing idea about anything related to mental health or healthcare. That's really true. And I've always been an advocate for, like, they should go to school for that. Like, because a lot of the times, a lot of cases involves people that are hurt, right? And again, mental health is not held in the light that it needs to be held. So that's a problem. So this next order or document basically is a stipulation for temporary orders on plaintiff's verified motion for temporary orders. So this is where Justin, the fiance, is requesting custody and parenting time, child support payment method, health insurance. It's just 2 pages. And then we'll get to the main document that I wanted to read to you guys. Like I said, I just started covering the KELSEY FITZSIMMONS case, and I will continue to support her. I'm trying to find other means of supporting her, or rather than the give, send, go. So I will let you guys know when I figure that out. So let me pull this document up. It's just a 2-page document. Here we go. Oh, that was the trauma letter. Okay, here we go. Yeah, this is it. Hello, Augie. Yes, a pneumothorax is a collapsed lung. Yeah, imagine breathing into that. Like, you have to like blow into it and it counts. It goes like ding, ding, and like it literally counts as you're breathing into it. You have to do it for like 3 to 5 seconds or some shit. And then it has you like suck it back in. And you have to like suck it back in for a certain amount of time. I wish I could show you guys. This document, okay, so let's continue. Custody and parenting time. This was filed on, oh, sorry, I lied. It's 4 pages. October 22nd. Just recently. Now comes the parties disgusting Justin and the defendant KELSEY FITZSIMMONS. Oh, Melly, why are you being judgmental? Why are you being a mean girl? Okay, fine. Yes, I am. I don't like Justin. I think there's better ways to have handled this, and fearing for your life to someone you were going to marry is questionable in the situation when you were supporting her for going through postpartum depression initially. So like, I guess I question your motives and your intentions and your ethics, Justin. Anyways, now the parties, the plaintiff Justin and the defendant KELSEY, hereby stipulate by through and counsel, temporary order, custody and parenting time. The father shall have legal and physical custody of the parent's minor child. Okay, while she's incarcerated for your lies. Caden is the baby boy. The parties acknowledged that on or about June 30th, 2025, a father sought and obtained a 209 abuse prevention order against the mother. Pursuant to the active 209 order, the father was granted custody of the minor child, and the mother was ordered not to contact the father or the minor child. This matter is scheduled for a 2-party evidentiary hearing on December 2nd, 2025. Again, why is a mother who's going through postpartum not allowed to see her child? Because she tried to take her own life? I don't understand. Okay, sure. Melanie, speak realistically. Okay, it might be harmful to the child in a sense of like, it's not a good mental place to be in. She doesn't deserve to lose complete custody or be incarcerated. The parties further acknowledge that the mother is currently being held without bail in the Western Massachusetts Regional Women's Correctional Center pending a criminal trial on a charge of assault with a dangerous weapon in the Essex Superior Court. In that matter, the mother was ordered to remain away from the minor child. As such, mother shall have no parenting time. This is so messed up. I can't even get over it. I am outraged. I am so upset and so mad for her. Like, again, isn't this causing attachment disorder, avoidant detachment disorder with the baby? Like, it's a newborn baby. This is brutal. 2, child support. Commencing on October 23rd, mother shall pay child support to the father in the amount of $12 per week. Really? $12 per week? The parties acknowledge that the child support of $12 per week is a minimum child support order pursuant to the Massachusetts Child Support Guidelines. I'm sorry, what does $12 pay for nowadays? I'm really confused here. Child support payment method. The party agrees and acknowledges that the mother holds title to the real property located at 120. So he's trying to take her house. that she paid for. Oh my gosh. I'm gonna break the computer. I know, Sarah. Sarah's like, I want to scream. I'm like, I'm gonna break the computer. No, yeah, he's trying to take her house. I'm not gonna read all of that, but that's basically what that means. Or in lieu of health insurance for the minor child, the father shall maintain his employer-sponsored medical insurance because his father is a firefighter. Uninsured medical, this is so messed up. Medical, dental, and vision expenses. It's a 4-month-old baby. Okay. Does the baby need glasses right now? Can we wait till she has like a fair day in court? Like everyone chill out. Like not you guys. I'm talking to the people in the courtroom. And like this ex-fiance, how do you want to marry this woman on October 4th and then you're saying that she cannot take care of her own child? She had already been taking care of the child. She was diagnosed in March. She had been watching the baby while her husband was working 24 to 48 hours a week. I want to scream. I know. Child care and daycare cost, I guess. I don't know. The parties shall share equally in any and all childcare or daycare expenses. This is messed up, guys. And then it says communication between the parties as noted above pursuant to the 209A. The mother is prohibited from contacting the father. That said, the parties agree that the father will share updates about the minor child, such as his diet, his general well-being, etc., his milestones, as well as photos or videos. This is messed up. Mother's child baptism. So the ex is trying to have the baby baptized while she's in jail. How effing petty do you have to be? Like, I'm serious. How effing petty, Justin, do you have to be? Like, I'm shook. This could happen to anyone too. Like, who knows? You could one day have a situation like this because you have some undealt with childhood trauma that you didn't know about. It's actually really true. That could happen. And then you end up losing everything because of that. Like, are you to blame? Like, who's to blame for your childhood trauma and or whether you have the funds to deal with that for your entire life? And then one day when you have an episode, it's like everything, they take everything away from you. Like, where is the support for people experiencing mental health issues? It's very hard. Luckily, from my personal experience, I did actually go through like a mental health period, but I did have the care I needed, luckily, but not everyone gets that. And it's rather expensive and it's just ridiculous that like he can do this while she's not well and incarcerated. Like, can you at least wait till she's well to make like good decisions and be involved? Like, she's literally dealing with postpartum depression. When you think of postpartum depression, think of Lindsay Clancy and Andrea Yates. Do you guys remember Andrea Yates? We should cover her like on my channel because it's a really old case, but like Andrea Yates will forever stick in my mind. Remember, she's the one who drowned her 4 children in a bathtub. And she was like in the hospital, in the mental asylum or whatever, mental hospital. And then they like, I think were allowing her to get out. And she still was like, no. I think if I'm right about her, because she was like, it's a condition that I'm always gonna have. It's passing trauma onto the baby. Exactly. Thank you, Sarah. Yes, it is. The baby needs his mom. Period. I don't care if it's supervised. Okay, fine. Supervised, whatever. My boyfriend did all this to me and my parents would be pulling a Donna Adelson. Yo. Yeah, true crime. True crime type of mind. Okay, this next document we're reading is, I'm like fuming. I can see why people were I was a little late to get into this case, but I'm just like, what the hell? Okay, I'm going to pull this one. I'm going to share the screen rather than have it pulled up or loaded up. This is the last document I'm going to read for today. But it's a rather very interesting one, and it gives a lot of background on, why isn't it pulling up, on the case as well. Okay. So this one is from October 2nd, 2025. What the hell, Melly? We said the same thing at the same time. This can happen to anyone. Yeah, it can. Can be anyone going through postpartum, even just going through like an alcohol problem and then having a mental health episode like at home. That could lead to all of this. Like, and why does someone have an alcohol problem? There's many reasons. It could be trauma, it could be addiction. Those are all diseases, mental health issues that people need help with. Yes. Oh, okay. I wonder if that's, thanks, Mal, for letting me know. Brother Counsel on X says she filed a full bench appeal. I have to watch him. I've been hearing things about him. Thank you, Mal, for the 199. Oh my God, this is all for your own baby you love, gave birth to, now your stupid boyfriend is destroying. Yeah, I have no words. On 10/24. Oh, okay. Brother Counsel on X says she filed a full bench appeal. I don't think it's this document because this one says defendant emergency petition for relief from revoking terms of release brought pursuant. So I'll have to find that one. I know someone offered yesterday to help with the docs, so that's really nice. Okay, let me. Okay, thank you for the super chat. Miss Kelsey Fitzsimmons, the petitioner, a North Andover police officer and former corrections officer, was on release out of the Essex Superior Court on pretrial conditions under 58A. Ms. Fitzsimmons had come back to court on her own motion through counsel after she was unable to blow into a scram alcohol monitoring device deeply enough to her sustaining a gunshot wound to her chest with attendant collapsed lung, broken ribs, diaphragm, and liver damage, requiring 53 days in the hospital. Counsel expected a short hearing where the defense reported the difficulties and had an alternative method of alcohol testing put in place. Instead, a completely improper nightmare scenario ensued. Rather than utilizing a readily available common alternative method of alcohol testing, the court surrendered the petitioner back to jail without a legal basis or a request to do so from either the Commonwealth or probation in violation of Section 58B. She berated and shut down the probation officer, cut off counsel, and walked off the bench while undersigned was arguing for his client. In writing, she accused the defense of manipulating the situation and repeatedly misstated the record. Ms. Fitzsimmons respectfully asked the single justice to review the full audio hearing provided herewith, take notes of all such instances, and vacate the trial order. She requests that single justice, 1, address the bail determination de novo consistent with the applicable case law reference. 2, grant Ms. Fitzsimmons liberty with personal recognizance and stay away order under Section 57 or Section 87, which is bail terms imposed with agreement of the defendant of the bail statute. 3, or other such non-incarcerative relief in the alternative if the single justice deems 58 necessary. 4, send the case back to the Essex, I hope I'm saying that right, Superior Court before a different judge for the reasons set forth below. The alcohol testing device ordered by the court requires petitioners to blow intensely into an attached tube several scheduled times per day. After attempting to use the device as required, Ms. Fitzsimmons, in good faith, returned promptly to the court to report that she could not use the device without great pain and dizziness for up to 4 hours, and aggravating the healing of her broken ribs. Pain and dizziness notwithstanding, she tried and immediately passed 8 out of 9 tests, and when she called the monitoring authority on the remaining incomplete test, after increasing breathing difficulty, she was told they may issue a warrant. which they ended up not. Between the physical pain and the anxiety of a warrant issuing, causing her to be arrested and taken to jail, despite her good faith attempts, Ms. Fitzsimmons, through counsel, returned to court right away of her own accord. Counsel filed an emergency motion to vacate the scram requirement in favor of an alternative testing method, i.e., urine testing or a bracelet that detects alcohol through sweat or the like. The defense intended to ask the court and probation for help, a reasonable accommodation with an alternative testing method, and instead was greeted with hostility, interruptions, obtuse posturing, presumptive skepticism, willful blindness as to the availability of other methods of testing, and grossly injudicious behavior, culminating in the court walking off the bench during the middle of the argument of the undersigned. At the hearing, the assistant chief probation officer testified that he witnessed that Ms. Fitzsimmons could not take the test without severe pain and discomfort, and that he was not seeking to surrender her or assert that she was in noncompliance. The defense also provided the court with the non-confirming email from the ACPO and the 2 affidavits from the petitioner and her mother detailing her struggles. Despite there being no surrender request, and despite the petitioner returning promptly and in good faith, seeking a readily available alternatives testing method, the court sua sponte denied the request for an alternative method and revoked her terms of release. The judge sent the seriously injured police officer and former corrections officer to jail for 180 days as a danger to the community because she couldn't blow into a breathing testing device intensely without causing pain and dizziness and aggravating her broken ribs. The case is comprised of only one sole indictment for assault by means of a dangerous weapon, a 5-year maximum felony for which she is eligible under the guidelines for a probationary sentence. On a theoretical plea, she would be a good candidate for a continuance without a finding. In contrast, she was released pre-trial under plethora of 58A conditions, more fitting for a career violent offender looking at years in prison. Yeah. And only after a substantial delay by the court micromanaging the release while she remained incarcerated. The record demonstrates that alcohol was not part of the incident in any way, and that the putative claim is in no danger from Miss Fitzsimmons. There it is. Alcohol has nothing to do with this, and she's back in jail while dealing with postpartum depression because she couldn't blow into this piece of shit cheap device that they have you blow into and that they make a ton of money off of. Because once it locks out after 3 times, you owe them like $100 each time. Thank you, Anton. Oh, you want to see me get down on the floor, get low? Okay. Maybe later. Insane in the membrane. I know. This is so messed up. I am outraged, you guys. This is like, I have no words how she feels right now being in a shitty jail, going through postpartum depression, knowing that the love of your life that you were going to marry is doing this to you, knowing that your house that you paid for is going to be given to this man, hopefully not. And one of your friends, the guy that shot her friend, her colleague, knowing that he betrayed you. Because why isn't he making this right? Why isn't the colleague making this right and saying, no, like that was my bad? Is he lying and saying that she did point the gun at him, or what's going on? I know some people will say, well, maybe she did, Melly, like maybe she was trying to shoot him. Well, there's no body cam footage. So at this point, that's not our fault. That's not her fault. That's not our problem, not her problem. Why there's no body cams? That's a political thing, right? Or whatever. I don't know. Whatever that is with the police department and who decides those things. I don't freaking know. The undisputed facts of the case are that Miss Fitzsimmons, approximately 5'3" and 110 pounds. Oh my gosh, this is who is a danger to the community. I'm more of a danger to the community physically. I mean, if you really want to talk. 5'3" and 110 pounds. And she was just shot in the chest. Who's scared? Are you guys scared? Can she even walk appropriately? Like, can she even sit straight? I'm just wondering. I'm over here hunching. But you know what I mean? She was shot, okay, approximately 5'3" and 110 pounds, was shot in the chest by a colleague on the North Andover Police Department who fired a 9mm projectile into her body while serving a 209 restraining order obtained by the ex parte by her fiance. Ex-fiance, please. Why did the order requires Miss Fitzsimmons to surrender her 5-month-old child? Oh, I thought he was 4. Maybe 4 at the time, to the fiance and surrender her firearms to police. In the space of 30 seconds, Miss Fitzsimmons, upset by the events taking place, realized she had been betrayed by her fiance, who had filed a false and self-serving, yes, self-serving affidavit after disappearing for 3 days. Oh, so he disappears after supporting her, then he disappears, and then he comes back trying to take everything from her. Yeah, typical of a big douchebag is what I have to say. My opinion only. Please don't let that influence you. I am just up here raging. Please do not unsubscribe. I'm generally not very much disaggressive, but I can be actually. She lost her baby without ever having a say in the matter and lost her job due to the nature of the order and the surrender of firearms. Ms. Fitzsimmons was diagnosed with postpartum depression several months earlier in March of 2025 and was on leave from the department while she raised her baby and convalesced. She had her firearm license restored and had just been cleared to return to work when the restraining order was obtained behind her back. And it was served on her by her colleagues on the NAPD who were taking her baby from her. I thought there's something wrong with this. I need a lawyer. Like, I need to explain this because I thought, was that allowed? Is that allowed for her colleagues to serve her when she's on leave on medical leave and like 3 males to serve her? I don't know why I feel like that's not right. Maybe not morally, but I don't know. Someone tell me if that's like against the law. Because if they knew she was on medical leave, shouldn't they have sent like I guess the appropriate people to her, which I don't know who that would be, like a mental health professional maybe, or maybe an officer trained in mental health. Ms. Fitzsimmons, being distressed due to the surprise restraining order and the bombshell just dropped on her, raised her firearm to the side of her head in a half-hearted attempt to inflict self-harm. She put the gun to her head and she was shot in the chest by Officer Patrick Noonan. Patrick, you better be telling the truth, Patrick. Noonan claimed Ms. Fitzsimmons pointed the gun at him and tried to pew him, which is vehemently denied by the petitioner. Initially based on Noonan's accusations, petitioner was charged with the assault with the intent to murder in violation 18 or 265 section 18, along with 2 counts of assault by means of a dangerous weapon in violation. No. No and no and no and no. Who all failed Kelsey here? Did her own department fail her, but not even giving her the appropriate mental health treatment? Like, I'm wondering about, the situation. Because there was like a situation the year prior. She walked in with the guy who shot her, right? Her colleague. They had a case. There was a case. They called the 911. Kelsey and Patrick show up. And it's a mom who allegedly unalived herself and her baby. And so that affected, what was the word? I forget the word she used in her document yesterday, where that's kind of what initiated the mental health issues. And then she had postpartum depression. This man, Patrick Noonan, if I'm saying that right, is the one who was with her and was her friend and was supportive. And now he's saying that she tried to shoot him. Like, is that true? That's messed up. The allegation of intent to murder, along with an extra assault by means charge, was rejected by the Essex grand jury, as confirmed in open court by the prosecutor. 1 count of assault with intent to murder and 1 count of assault by means of a dangerous weapon. Charges were brought for consideration, and only a sole charge of assault by means was true billed by the grand jury. The prosecution was unable to establish probable cause that there was intent to murder in its most favorable and scrutiny free forum and came with probable cause for the mens rea of only assault. There was no intent to murder, no malice, no evil intent, only suicidal desperation endangered by postpartum depression, a scenario that cannot justify a judicial declaration that Ms. Fitzsimmons, a police officer and former corrections officer, must be locked up with no possible alternative as a danger to society and to the armed and trained police officer who almost killed her. The trial's court order is heartless as it is legally baseless and must be reversed. Yes. Requiring that bail be revoked only after finding that there is no combination of conditions that would allow the defendant's release furthers the bail statute's purpose of, quote unquote, establishing the right of the accused in most circumstances to be admitted to bail. This case firmly fits into the broad category of circumstances where the accused, a candidate for probation and or continuance without finding, should be admitted to bail. Yeah, why is she incarcerated again? Oh my goodness. Single justice for jurisdiction for bail issue. The proper means for review of errors attended to a trial court bail revocation is through a petition to the single justice, invoking the court's inherent authority to correct errors and abuses in the inferior courts. I'm gonna skip this part. Actually, I'm not gonna skip it. I lost my place. Great. Oh yeah, right here. Two leading. Okay, it's talking about Commonwealth versus Pagan. We therefore hold the, okay, it's talking about this case. Similarly, we think the full court has jurisdiction to review on exemptions, report, or appeal questions of law arising in bail determination. Okay, Commonwealth. In addition to confirming such jurisdiction in the single justice session and the full court for questions of law, the Comesso bench allowed de novo review of bail determination. The statute is not explicit as a role of single justice. I don't know what that means. We therefore think that the single justice has the power to consider the matter anew, taking into account facts newly presented, and to exercise his own judgment and discretion without remanding the matter for reconsideration by the Superior Court judge. Thus, the single justice session is a proper forum and framework for review and is in place to satisfy the need for speedy resolution for an incarcerated petitioner by allowing the single justice to decide the matter anew without remand under Comesso Supra. This is then the possibility of an appeal to the full bench on errors of law only. Ah, that's what Melanie was talking about. Applicable bail statute. Here, Ms. Fitzsimmons was wrongly surrendered in violation of 276-58B. Section 58B limits the circumstances under which a trial court judge may surrender or revoke the 58 release of the detainee. This is as follows. Section 58B, a person who has been released after a hearing pursuant to sections 42, 58, 58A, or 87, and who has violated a condition of his release shall be subject to a revocation of release and an order of detention. The judicial officer shall enter an order of revocation and detention if after a hearing the judicial officer finds that 1, there is probable cause to believe that the person has committed a federal or state crime while on release, or clear and convincing evidence that the person has violated any other condition of release, and 2, that the judicial officer finds that there are no conditions of release that will reasonably assure the person will not pose a danger to the safety of any other person or the community, or the person is unlikely to abide by any condition or combination of conditions of release. First of all, Kelsey is not a danger to the community. Like, she's going through postpartum depression. Okay, I will. Terrible judge. I agree. Family law varies by state. California law wouldn't necessarily be the same in Mass. That's true. Evil intent isn't something the law weighs anyways. You need to read the statements. Okay, I'm going to try to get those. True crime. De novo review is an appellate standard. The judge brought this up for some reason I didn't catch. He's saying she wasn't supposed to. Yeah, mental health issues, they should have helped her make it make sense. Yeah, exactly. By the plain words of the statute, orders of revocation and detention are only permissible if there is a clear and convincing evidence of violation of release and there are no conditions of release that will assure the safety of any other person or the community, or the person is unlikely to comply with the condition of release. Here, the court's sua sponte imprisonment of Ms. Fitzsimmons runs afoul of the statute. Ms. Fitzsimmons did not violate a condition of release. She was there in good faith to avoid difficulty going forward. The Commonwealth, to its credit, recognized the situation as such and only wanted her to continue to be tested. When asked for its position or evidence, the prosecutor said, quote unquote, no evidence to submit other than the arguments that I talked about how the Commonwealth's belief is, in light of the court releasing the defendant, that testing can be done. There was no allegation of a violation or a request to hold a 50AB hearing or any request to send her back to jail, just a request that the testing continue. So she shouldn't even have gone back to jail. So why is she in jail again? That's messed up. She shouldn't even be. It's saying that doesn't even should qualify her back in jail. Nor did probation seek any hearing on revocation or allegation of noncompliance or notice of surrender. To the contrary, Assistant Chief Probation Officer Jeff January fully supported as an alternative testing means, but was completely shut down by the judge, who became increasingly angry that he was confirming and corroborating the defense motion with his personal knowledge. He said, as recorded at 1217, see Exhibit 9, provided herewith, quote unquote, my first job when we get incomplete test is to gather information, which is what we do. So in response to the incomplete test, we call Elmo. We gather this information, which is, she answered the alert to take the test as scheduled. So Elmo is the monitoring company. You guys are wondering who Elmo was. So yeah, basically, which she's answered, okay, the test is scheduled. She unfortunately was unable to complete the test because she was unable to blow as long or as hard as needed to complete the test. So she tried, she just couldn't, it times you. So ultimately at 4:20, she completes the scheduled test. There may be additional attempts in between, but ultimately she completes the test. In conjunction to the 2-hour and 20-minute, we also know, I observed it firsthand, that whatever the injuries are, and I don't know, and it doesn't really matter to me. When I was doing the installation process and observed the genuine pain, court, any objection to any of the terms used by the probationer? No. Okay. We have all that information. We don't deem that non-compliant. She is attempting to take the test and she ultimately passes the test at 4:20. So with all of that information, that's not compliant. That's compliance with her obstacles. That's compliant with the scram testing. Yeah, I agree. If she had missed the test, that would generate additional responses from Elmo, and that would determine whether or not that was actual non-compliance. This particular case, I don't deem non-compliance because she's complying with a scheduled program. I'm aware of pain based on the observations from the installation process. So the person who installed her bracelet is noticing this. So, and this is what he's saying. So as long as she's attempting to take the test, continues to attempt to take the test, and then ultimately takes the test, that's not non-compliance. That's someone that's, and the court interrupts, well, that's your position. That's not compliant. It's really up to the court to determine whether someone is compliant or not with the conditions of release. Actually, how is that even ethically right? How can the court determine that? They're not the ones monitoring the device. It's Elmo. This is shady as hell. I guess I don't know Massachusetts law. And you know what? Good thing I don't live there, because I would probably be incarcerated too. It would never be brought to court by way of pretrial violation for an incomplete test with the information that I've talked about. So no, an incomplete test does not initiate a pretrial violation notice from our end because there are many reasons for a test to be incomplete. The goal is to The goal is to test to ensure that the person is sober, and we don't deem that non-compliance. We would never have, and we never would in the case, initiate a pretrial violation proceeding based on an incomplete test that was subsequently passed. The schedule for her to be tested is something that we discussed. It wasn't ordered by the court. The court ordered someone to be alcohol-free. The court interrupts. What do you mean we discussed? So she knows what she's going to be tested? I discussed with Ms. Fitzsimmons, I discussed with the defense counsel about creating a testing schedule because it's more practical to have a schedule in place. There was no schedule that was ordered by the court. There's no frequency, the court says. It was random screens. Excuse me, Officer January. It was random screens. Now you're telling me she's on schedule to get tested? Is that what you're telling me? And then he says, we created a schedule as we always do, not in this particular case. We always do. Court, it was random screens that were ordered. When we get an order and someone is placed on pretrial conditions, that includes remaining alcohol-free with scram testing, we always default to creating a testing schedule up to 4 times a day. Up to 4 times a day. The one I had was like 12 times a day. The only way we would not enter a schedule is if the court specifically said, I want the test to be done randomly. I don't want her to know when the tests are coming, and I want the test to be done randomly. The court was incorrect and random testing was not ordered. There's no such order on the probation contract, and undersigned recalls no such order. Such hearing recording, okay, whether random or scheduled, no loophole would have been created either way for undetected alcohol consumption. The court should have allowed an alternative testing method. The petitioner, KELSEY FITZSIMMONS. Ms. Fitzsimmons is a lifelong North Shore resident with indelible roots in the community from her upbringing, family, friends, job, and education. She went through the Methuen public school system for kindergarten to senior year in high school. Once she graduated high school, she continued her education at Fisher College in Boston, majoring in criminal justice. She chose criminal justice with the goal of becoming a police officer, a career that was a lifelong calling for her. While studying criminal justice, she became the president of the Criminal Justice Club, where she was responsible for hosting events on campus that pertained to important topics related to the criminal justice, such as DV, suicide awareness, fire safety, etc. She was inducted into the Criminal Justice Honor Society. So she was even a resource in that same suicide awareness community, and she ended up suffering from it and gets thrown in jail. Ms. Fitzsimmons held a position at 2 different jobs that pertained to her major. Through Fisher College Campus Police, she held a work-study position as a dorm proctor, where she was responsible for checking the IDs of everyone who entered the dorm building and ensuring that all students were following the dorm rules and regulations. She also obtained a job working at Fenway Park. As security at Fenway, she interacted with fans and guests, had to be observant and proactive for any disruptive behavior occurring during games or concerts, and also screen and search fans before they entered the park. KELSEY graduated college in May of 2020 during the peak of the pandemic. Unfortunately, her career plans were delayed as there were no police academies running during this time. She decided to continue her education and go to law school, and took night classes while working as a paralegal during the day. After completing her first year of law school, she realized it was not her passion. She then applied to the Essex County Sheriff's Department, completed the academy, and was employed as a corrections officer there for over 2 years. In KELSEY's own words, quote unquote, working as a correction officer taught me a lot, and that was a great stepping stone, but I knew my end goal was to be a police officer. I applied to the North Andover Police Department, went through the hiring process, and was accepted into the police academy. I successfully completed the police academy while holding the position as treasurer of the academy. I then was sworn into the North Andover Police Department and successfully completed my required hours of field training. After a lot of hard work and a lot of years of gaining experience to get where I wanted to be, I finally had my dream job of being a police officer. I knew that there was no other job that would fulfill me like this one. Ms. Fitzsimmons had dedicated her life to 2 things: her law enforcement career, and her baby. She has never harmed or threatened to harm her baby. Like countless new mothers, she had suffered from a transient bout of postpartum depression. She has also been found by an expert clinician to be not dangerous and deserving of reunification immediately with her child. See report of the CV, Dr. Paul Zeisel. As of the day of the incident, she was cleared to return to work as a police officer. Her license to carry was restored. So she was out on leave for medical leave, and then she was given back her responsibilities. So she was reliable. She's scheduled to be returning to work on July 4th, 2025. That day of June 30th, her significant other and baby's father betrayed her with lies and false allegations designed to take her baby from her and extract himself in the worst faith and cowardly fashion imaginable from their relationship. He told her to meet him at the local park and instead stood her and the baby up, and instead went and got an ex parte restraining order with an affidavit full of shocking lies. Wow. He told her to meet him at a local park and instead stood her and the baby up and went and got a restraining order. Kelsey went home, and 3 male North Andover police officers came to the house serving the order, taking the baby, her future marriage, and her career with them all at once in the space of minutes, without her even being heard or being able to defend herself. She never pointed a gun at any officer. Unfortunately, the department's decision to avoid body cameras leaves the case as he said, she said exercise and seriously affects the strength of the Commonwealth's case, a highly relevant factor in the bail determination. Kelsey was shot in her chest and has been hospitalized fighting for her life since June 30th of 2025. After the instant shooting endangering her life and resulting in the charges against her, Ms. Fitzsimmons has gone on record adamantly denying the allegation that she pointed a gun at a colleague and a fellow law enforcement officer. She is also entitled to the presumption of personal recognizance. These imputable principles come together in this case to compel only one result: release on personal recognizance with a stay away order. Factual errors by the court. In seeking to defend the indefensible, the court resorted to attacking the attorneys on alleged procedural deficiencies and manipulations in its writing rulings on the events of September 11th, and in denying the reconsideration and ignoring the medical evidence it claimed was initially missing. The court apparently forgot that at a prior hearing, the court suggested, and the defense agreed, that the facts in the prior filings would be incorporated by reference so all facts could be before the court. In its ruling, the court apparently ignored this position, claiming a lack of medical evidence and a lack of specifics on simple urine testing that is ordered and or referenced in court likely every single day and undoubtedly utilized by this very court over her several years of experience. The record appendix contains everything filed for the trial court's consideration and was, as far as undersigned counsel understood and expected, incorporated into the judge's state of knowledge on the bail determination as a whole. The court's focus on the state of the record was unexpected and inconsistent with the history of the proceedings. During the September 11th hearing for motion for relief, the court incorrectly stated that it had no medical support, whereas defense counsel has submitted a medical notice to the court prior to the petitioner's initial release on September 8th. The medical note laid out various issues. Ms. Fitzsimmons was suffering with and including difficulty breathing, broken ribs, and other items provided in Exhibit 12, which was impounded at a defense request. So that was a letter from the doctor that we read. She's in jail because she admitted to grabbing a firearm without a right to do so. Yeah, but she's trying to unalive herself, not the other police. But we do need more cops like her. Further, Ms. Fitzsimmons being shot in the chest is laid out in the initial charging documents filed, and certainly no secret in the matter. The court was aware as early as the second hearing on September 8th that Ms. Fitzsimmons had difficulty breathing due to her healing punctured lungs and broken ribs. Finally, the court had affidavits from the defendant and family, as well as 2 reports from a psychiatrist and a psychologist. In response to the court's revocation claiming a deficiency in the medical documentation, defense counsel further provided the court with a difficult to obtain letter directly from Ms. Fitzsimmons, very busy trauma surgeon, removing any issue whatsoever. Oh, this is the letter we read. Dr. Parks corroborated petitioner's medical notice, her mother and the ACPO, and opined, in my medical opinion, a fracture of the 12th rib can cause pain that may persist for several months after the injury. The severity and duration of pain following such a fracture varies, and it is difficult to predict how long symptoms will continue in any given patient. Additionally, retained bullet fragments can also cause chronic pain that can be exacerbated by movements such as deep breathing. The court ignored what it demanded in its denial of the reconsideration motion. The court also ignored the second to last section of 58A, which provides the judicial officer may at any time amend the order to impose additional or different conditions of release. Further, the court erred in citing 58A as the applicable circumstance and finding noncompliance. The court was using the wrong statute. This hearing was not a reopening of 58A. This was the court revoking release under 58B. That's where that comment I said earlier came from, which clearly, as set forth herein, did not conform to the requirements for such action. Further, the court misstated the record, alleging that defense counsel did not provide alternatives to scram breathing. Urine testing is a common tool used by the trial court every day and not a complicated or obscure request by petitioner. Counsel did, in fact, reference testing alternatives at several times during the September 11th scram hearing. Unfortunately, the court's demeanor severely curtailed any elaboration from probation or counsel, culminating in the court preventing any further discussion by walking off the bench mid-argument of undersigned. The defense requested alternative testing, which was readily available and reserved specifics for later to avoid further enraging the court. And the court, leaving mid-argument, prevented the remainder of the information coming out. That's so wrong. The court violated the Americans with Disabilities Act in finding that after a thorough review of all the arguments and submissions by the Commonwealth and Fitzsimmons, that conclusion remains unchanged regardless of Fitzsimmons' claimed physical limitations. The court violated Title II of the Americans with Disability Acts, prohibiting the discrimination against people with disabilities in pretrial services without reasonable modifications. At the time the condition was imposed, Ms. Fitzsimmons had recently sustained life-threatening injuries, including gunshot wound to the right chest, hemothorax with retained bullet fragments in the right upper back, moderate right hemothorax requiring chest tube placement, right middle and lower loop pulmonary contusions with active bleeding, grade IV hepatic trauma with active bleeding from the right hepatic lobe, comminuted right posterior 12th rib fracture, and a right anterior 11th rib fracture at the costochondral injection. She was clearly disabled under the ADA. The U.S. Department of Justice Civil Rights Division has directly addressed the ADA's applicability to the situation in its information and technical assistance on the ADA guidance letter as follows. Title II of the American with Disabilities Act protects people with disabilities from discrimination in state and local government services, programs, and activities, including law enforcement agencies, justice system entities, and juvenile and adult corrections agencies. The ADA requires criminal justice entities, including attorneys, courts, jails, juvenile justice entities, police, prisons, prosecutors, and public defense attorneys to avoid discriminating against people with disabilities. Entities must ensure that people with disabilities are treated equally in the criminal justice system and that they have equal opportunity to benefit from safe and inclusive communities. Non-discrimination requirements, such as the obligation to provide reasonable modification to policies, practices, and procedures, and the obligation to take appropriate steps to communicate effectively with people with disabilities, also supports the goal of ensuring public safety, promoting public welfare, and avoiding unnecessary criminal injustice involvement for for people with disabilities. As a result of her gunshot wound, Ms. Fitzsimmons has severely diminished lung capacity and suffers acute pain when attempting to inhale or exhale deeply. Her treating physician has medically opined that a fracture of the 12th rib can cause pain that may persist for several months after the injury. The severity and duration of pain following such a fracture vary, and it's difficult to predict how long symptoms will continue in any given patient. Additionally, retained bullet fragments can also cause chronic pain that can be exacerbated by movement, such as breathing. Thus, an individual suffering from the conditions in which Ms. Fitzsimmons would make an individual medically incapable of blowing with sufficient force or duration to activate or register a reading on a SCRAM breathing device. Despite these limitations, a SCRAM device was installed on September 8th. On September 10th, Ms. Fitzsimmons, through counsel, filed the motion for immediate relief from SCRAM, which was met with Ms. Fitzsimmons' immediate incarceration by the court. So she, even with her lawyer, went and let them know, like, hey, she's struggling with this. She can't do this. They did the right thing, and then she was arrested at court. On September 11th, 2025, immediate following the revocation, she filed a motion for reconsideration, which provided the email from probation and requested reasonable accommodations, including an alternative alcohol monitoring method. Finally, on September 15th, Ms. Fitzsimmons, through counsel, filed a supplemental filing on pending reconsideration, but the request for reconsideration was denied without a hearing. In doing so, the court explicitly referenced but ignored her physical limitations and the reconsideration denial opinion. The court revoked Ms. Fitzsimmons' bail and ordered her detained solely on the basis of her noncompliance with a physically impossible condition. Under Title II of the ADA, no qualified individual with a disability shall, by reason of such disability, be excluded from participation in or be denied the benefits of the service, programs, or activities of a public entity. The judiciary, including courts and probation departments, constitutes as a public entity within the meaning of the statute and must comply with its mandates. A qualified individual with a disability is defined as someone who has a physical or mental impairment that substantially limits a major life activity and is eligible to receive public services or participate in public programs. Here, Ms. Fitzsimmons is a qualified individual with a disability due to her gunshot-related injuries, which substantially limit her ability to breathe and perform physical tasks. She was denied the full benefit of the pretrial release program solely because of her inability to perform a task incompatible with her medical condition and was denied a reasonable modification or alternative that would allow her to participate in the alcohol monitoring on equal terms with non-disabled individuals. The failure to accommodate her disability and the punitive consequences of that failure through pretrial incarceration constitutes a violation of her rights under the ADA, easily remediable with available accommodations. Yeah, no, really, like they did violate her rights. She literally got shot in the chest. These are numerous alternative alcohol monitoring options available, including transdermal SCRAM bracelets, random urine analysis testing, and in-person probation check-ins. Each of these is medically appropriate for the petitioner and serves the court interest in monitoring substance use without violating the ADA or imposing impossible requirements. It is not too much to ask the court to accommodate Ms. Fitzsimmons' conclusively demonstrated disability with an alternative testing method and not violate the federal disability law to enforce a dubious procedural position. The errors of law. Finally, the court erred when it misstated that the standard for using hearsay in a probation hearing. The court improperly stated in the hearing that the email from the probation is not evidence. It's an email. It's hearsay. And this email from a probation officer, the court gives zero weight. The court's determination on the email from Assistant Chief Probation Officer Jeffrey January as hearsay and not evidence is an error of law, as the rules concerning admissibility of evidence in criminal trials should not apply to the presentation and consideration of information at the hearing, and the judge shall consider hearsay contained in a police report or the statement of an alleged victim or witness. In its September 16th decision, the court asserted that hearsay must be reliable and there must be good cause for the decision to not present live testimony. Yeah, I think the probation officers their statement is reliable. In doing so, 1000%. In doing so, the court failed to acknowledge the abandonment of the good cause requirement as stated in Commonwealth versus Henderson, which states, quote unquote, ordinarily, the revocation judge should excuse the witness originating the hearsay information only for good cause. However, if the hearsay information satisfies the standard of substantial reliability or trustworthiness, the need to show good cause disappears. Accordingly, the court was applying a legal faulty standard to the evidence presented by the defense and should have fully credited his contemporaneous documentation of Ms. Fitzsimmons' difficulties. Conclusion. The court clearly dispensed with the safeguard that bail be revoked only after finding that there is no combination of conditions that would allow the defendant's release, which then furthers the bail statute's purpose of establishing the right of the accused in most circumstances to be admitted to bail. There are ample alternatives to incarceration for Ms. Fitzsimmons, which were for some reason assiduously avoided by the trial court. For the foregoing reasons, Ms. Fitzsimmons respectfully requests that the single justice hear the matter regarding her bail revocation, vacate the ruling of the Superior Court revoking bail, and return her to liberty by granting personal recognizance with a stay order or such other conditions under sections 57 or 87 of the bail statutes, or such 58 orders as of the single justice deems necessary. Finally, she requests that the justice enter any further orders and rulings necessary to effectuate her request and any such other relief as the justice deems proper. October 2nd. Wow. These are great arguments. I know. Tim Bradle, I believe, yeah, Tim Bradle's her lawyer. I believe it's Turtle Boy's lawyer as well, if I'm not mistaken. Wow. I 1000% agree with everything that document stated about her. She should deserve another chance or another manner of alcohol testing. She shouldn't be incarcerated for that. They could have done house arrest. She's going through postpartum stuff. I'm shook. Nothing about it all was ethical. I just can't believe the alcohol wasn't even a factor in the incident, and now she's jailed for non-compliance. I know. It's horrifying. It's sick. This will be an interesting appeal. The ADA argument seems solid, but this lawyer did say she could have taken the test. That's going to hold them back. It's so sad. It's so sad. So I will be continuing Kelsey Fitzsimmons as I get more documents. I have a bunch right now I have to just go through. They're not in any order. I'm just picking the ones that I can get and that are most important. We will continue to follow this. I will post the Give, Send, Go for Kelsey. So if you want to donate, you can in the description, and then the next court date as well. I thought was November 25th, if I'm right, is the next hearing. So we'll definitely stay caught up on this. Thank you so much to eat. Thanks for listening, Evie. Thank you guys so much for being here. Please hit the like button on your way out. We will be back with another live. And I will add this to the Kelsey playlist. Definitely make sure you check out all of the playlists and all of the videos. I appreciate you guys for being here, and shout out to my mods. I will see you guys shortly on the next one. Bye.